Hello, everybody.
Call your matter, please, if you can, with Mr. Horn. 20001470, the people of the city of Clawson versus Anthony Michael Horn.
Ren Nosha on behalf of the city of Clawson. Anthony Moore.
Are you still using an address on Virginia Circle in New Haven?
I am.
Okay, today is a date and time for sentencing and about 50 different motions that
Yes,
I've
sir.
received.
If I may make it a little simpler for the court.
Okay.
Please. Judge, Mr. Horn filed a series of motions. One of them was a motion to set aside the plea in this case. And I had received it as an email attachment with no exhibits attached to it. I responded to it. And I addressed the fact that I saw there was mention in the motion, the body of the motion, of newly discovered evidence. I didn't see any of it. I responded to the motion. I responded to a few of the other motions as well. But this morning, I did receive from Mr. Romanzi a printed copy of the text exchange between what purports to be the defendant as well as the complaining witness. I take it at face value if this is a true and accurate statement of the text exchange. It looks true and accurate. That being the case, upon review, it appears that the statements from Mr. Horn's motion are correct. The evidence here stands for the proposition that the complaining witness has fabricated the entire story. That being the case, Judge, at this time, without more, I will stipulate with brother counsel to dismiss to set aside the plea. And upon the court doing so, I will move to dismiss the charge without prejudice. And I have indicated to brother counsel that I forwarded the same to the Clawson PD. They'll verify and resubmit for charges against the complaining witness. All support.
Okay, so before I have you place on the record what I'm assuming will be your concurrence with this relief today, there was a motion that was filed by Mr. Horn seeking for an opportunity to proceed without an attorney representing him. I just want to confirm, at least for purposes of proceeding in this manner, if that motion is off the table so you can appear on his behalf today.
Yes.
Okay, so, and you had always had the ability to have a public defender represent you. I know part of what you had placed in some of the motions where you were asking the court to consider your request to set aside your plea. There were some statements made there, but Mr. Romanzi was appointed today because at the time that we had adjourned sentencing, I wanted to make sure that you still had representation. We had talked about your ability to retain an attorney. Obviously, you had filed a motion seeking an ability to proceed without representation. But for purposes of proceeding in what I expect to be the manner that's been outlined on the record by the prosecutor, I just would like to confirm on the record that you want to continue being represented by an attorney, specifically Mr. Romanzi, just for purposes of today. Is that correct?
Yes,
Okay. Any objection to what's been stated on the record by the people regarding their intention?
No objection. Yeah, and I just wanted to perhaps clarifying statements. Mr. I did not receive text because I understand it. The text went attached to the motion to dismiss public defender received without an attorney. In an effort to get them in the record in response to the answer to the motion to withdraw. So those came later. So Mr. Nusha's response to the motion to withdraw the plea, he did not have those in his possession. That last motion was only emailed to the court, and I couldn't even get a copy of it, so I didn't have the text right until yesterday. Then the only other issue was when I looked at it, I said, "Well, how do I know this is the right number?" So I called it and I spoke to the person, and the person verified that that was the card. So let the court know.
Okay.
Verified.
And your client is in fact still asking for his plea of guilty to be set aside.
Correct.
And it appears, based on everything that's been placed on the record today and the due diligence on the part of both attorneys here, with Mr. Romanzi representing your interests, that it would be appropriate to allow you to withdraw your plea without getting into really any sort of legal analysis about whether or not it was voluntarily given to the court. I don't think we need to address that today based on the position that the city is taking. So I am going to allow that plea to be withdrawn at this time, and then I will grant the city of Clausen's motion to dismiss both original charges. So one was dismissed as a part of the plea, but because we're setting aside the plea and then moving back really to the beginning, the motion the city of Clausen is making is to dismiss both of those charges, which I'll grant at this time. They are dismissals without prejudice. However, I think it's been made clear on the record how the city of Clausen intends to proceed. Not returning to this issue again, that's before the court. All of your bond conditions are extinguished today. I think you had actually posted a bond at some point, but it was forfeited way back in 2020. I don't see any new bonds that would be returned to you, but all of your other conditions are extinguished at this time. Okay, thank you.
Thank you very much.
2500820, people of the city of Troy versus Carla Marshall Stevenson.
May I please the court, Nicole Becklin on behalf of the city of Troy.
Your Honor, Richard Hopper on behalf of Ms. Stevenson, who is present. Would you state your name for the court, please?
Ron Stevenson.
She's here for pretrial today. There's some other issues as well, as I understand it. But as far as the pretrial goes, she has already executed a waiver of jury form. She and I talked about this case, the merits of it, the defenses, and she would like to ask the court to accept that waiver and trust.
That's correct, Your Honor. The city would also waive request that they have the matter be set for bench.
All right, so let me first talk to your client about that waiver, and then we'll talk about what's happening with bond. So Ms. Stevenson, are you still using a mailing address on Terry
Yes.
in Detroit?
Yes.
Did you hear and understand what your attorney has just placed on the record regarding your constitutional right to a jury trial?
Yes.
So as you appear before the court today, you have been charged with the misdemeanor offense of domestic violence. Along with these charges comes a constitutional right that you can exercise to proceed to a jury trial, where the people of the city of Troy would be required to present their evidence before a jury of 6 people, and they would have to establish beyond a reasonable doubt that you in fact committed the alleged offense. Do you understand that?
Yes.
So in discussing the potential waiver of your right to a jury trial, you are not giving up your right to a trial. You are maintaining that right, and you're not guilty plea. The difference that you would be making today, if the court accepts your waiver, that instead of having the city of Troy required to present their evidence before a jury to make a decision as to whether or not they've proven your guilt beyond a reasonable doubt, they would have the exact same burden, but they would have to present the evidence to the court. And I, as the judge, would hear and see the evidence that's presented and make a determination if they've met their burden. Do you understand that?
Yes.
Have you had an opportunity to ask any questions that you have about this right to your attorney, Mr. Halpern?
Yes.
And you understand that if I accept your waiver today, we won't be coming back to court at a later date to tell me that you've just simply changed your mind and you'd like it placed back on the jury selection docket.
Yes.
Knowing all of this, are you proceeding today with a waiver of your right to a jury trial? Okay, I'm going to accept the waiver. It's been placed on the record here in open court, and I believe it's been provided to the court after an opportunity to consult with counsel. So we can talk about a date to set this, but I think we should probably talk about bond first. So it looks like Miss Stevenson was recently arraigned, 3/5/2025, arraigned by the magistrate and provided with a number of conditions that she was required to comply with. The first issue that came to the court's attention regarding bond was the fact that she was ordered not to have in her possession any weapons or firearms. She filled out an affidavit and signed under oath that she'd not surrendered any firearms or dangerous weapons because she doesn't have any. However, when we passed on her affidavit to the police department, there was information returned to the court that she has 2 pistols that are registered in her name. So that's one issue that we need to address that I would find to be pretty significant. And then it looks like there's a recent allegation that she was told not to have any contact with the complaining witness in this case. And there was some information that I believe was forwarded to the bond compliance officer that's in charge of overseeing her conditions that seems to indicate that she has failed to comply with that. Have you gone over these allegations? And does she understand that just because the allegations are made, she doesn't have to accept them as true and she could request a hearing?
We've discussed that.
What is she intending to do today?
All right, so there are two listed violations. One of them was with regard to the weapons. She does not dispute that there are two that are listed in her name. As a result, the bigger picture of this case, she had lost her housing and possessions. And so the weapons are not in her possession. She has no access to them. She doesn't know where they were last. They were at a previous residence. But when she left that residence, those weapons were left behind. So
Did she file a police report in that jurisdiction where she believes her weapons were left behind?
I don't believe she did.
No.
What city was that in? Redford. Okay, so we would need to start there.
There,
You don't have access to it, is that correct?
right, so I wasn't sure how to do that. I did try making a police report several times though about my belongings in the locker. When I was having contact with the police, they were telling me that it was civil and there was nothing I could do.
Well, that's not an untrue statement, but if you tell them that you have two firearms that are registered in your name and you've lost them and don't know where they are, they would likely take a police report from you. So when did that happen?
Yeah.
Oh, good.
It's several
It's
times.
still timely, though. It sounds like. Are you saying that just happened 2 weeks ago?
Within the last 2 weeks, is that fair to say?
That's what it
Yes.
is.
Okay, I'll direct her accordingly as to that part.
So that's gonna be a court order, that she has to go down there and make a police report, which hopefully is truthful in nature. Because that would present other issues for her if it was not. And she'll have to make a police report and bring a copy of the report to bond compliance. What about the other issue relative to the no contact violation that's being alleged?
As I understand it, the alleged date was on the 8th of March. My client indicates that she did not initiate contact as a result of this violation, that the involved parties did interact at a mall, but it was not my client that initiated it. Fairly brief. My client does not want to get herself in a position where she's violating the bond, and so it happened, I'm told, on her end, it was inadvertent. There's a child in common, and that may have been the basis of contact.
That's my understanding as well, Your Honor, and I do have the victim, the complaining witness in court today. We did want to address the court as it relates specifically to allowing contact with a third party for them to facilitate transitioning, or I guess parenting time with the child, having a third party help orchestrate that. So I do know that there was the violation on the 8th. Since then, however, I've confirmed with the victim that there's been no contact whatsoever at all. He's, which is why he's here. I think he would like to ask the court to allow some contact so that he can figure out how to see his child.
There's no custodial order. The mother's had the child. Father, I think, is earnestly interested in seeing the child. My client does not want to violate any terms of her release, but is willing to have a third party facilitate that parenting time. And if a third party being involved is going to alleviate any concerns about any kind of contact.
So what I think you're explaining to me is that there really isn't an ability for Ms. Stevenson to contest the bond violation allegation, but you're asking me to consider that it was inadvertent and
not initiated by her.
Okay. So when she was arraigned by the magistrate, I see that she was specifically advised she couldn't have any contact with the complaining witness and could not return to the address in Troy and Bellhaven. She was also advised that third party must be utilized for child exchange, and child exchange could only occur in the Troy Police Department lobby. So there was some specific information that was already outlined by the magistrate. Doesn't mean it can't change, but it certainly didn't say that that could occur at the Fairlane Mall. So we need to make sure that we've got a good sense of where the parties will exchange if it's not going to be what's currently ordered.
Yeah, and we didn't get into the specifics of the specifics, other than my clients indicated to me that there are family members that she has in mind that would facilitate that exchange. We'll keep her out of the loop.
So rather than go back and forth on the record to try to determine an agreed upon third party, because you are here and representing her for today, and because I'm going to talk about setting a bench trial, and I would request if you're available to stay on, I know it's not the court's decision, but I would like to address that so that an attorney can be appointed for her for the trial that will be set today. I would ask that while the parties are still here present, there is a named individual that's agreed upon, and then I'm going to place it in the court order as the third party. And then for right now, my intention is to leave the exchange at the Troy Police Department lobby unless the parties tell me a different place that they're going to exchange that's a public area. Because I think that that's the easiest way to ensure that everybody is following the court's orders and there's no inadvertent, I guess, chance of running into each other for this type of purpose. It will be very clear who they can utilize to set up the child visitation and contact, and then where they would make those exchanges. And that's really for the protection, I think, of both people involved at this point while your client's on bond. And I have a concern about maintaining safety for the complaining witness. That's my preference today before allowing these parties to just have free contact with each other. Right.
Pick that location off the record.
I want you to figure it out, the location and the third party, as long as it's agreed upon, but you have to give it to me before we send the file out to the front.
Sure.
10:30 on the 23rd, Wednesday.
I think I can make that work.
What about you, Ms. McMillan?
So Your Honor, I'm the vice chair on the OCBA Municipal Law Committee, and then we have our meeting at noon.
Okay,
Yeah, I mean, if, as long as we can be done by 11:45, I can be here before.
what do you think?
I think if we start at 10:30, I think we're looking at an hour. There's probably 2 or 3 witnesses.
I just have the complaining witness. But I don't know that I could get a complaining witness, and then in the event your client wishes to take the stand, I don't know that we can do 2 witnesses in an hour. I'm not as optimistic as you are about that time frame, but
I don't think there's gonna be that much to discuss or testify to.
it could go, it could be, you just, you know, there's.
We want to do it, and then if we don't finish, come back another time. But
Otherwise, we're looking up to May 12th.
I mean, I'm okay with starting on the 23rd and trying to get as much done as we can and hopefully finishing.
I think we start on time, we'll do it.
Okay, starting on time will be dependent on another motion that I think that you have. Is that a signatory case? That you may or may not be aware of yet. I don't know.
Not yet. Yeah, okay.
It's gonna be in mine. All right, so let's just pick that date. Let's confirm availability of all the witnesses. This is going to, of course, be dependent on continued compliance with bond. So I'll wait to see what's determined about exchange for the child and the location. And then Ms. Stevenson, you have a very short period of time. I would like by Friday, end of the day, to have a report from the Redford Police Department, even if it's just an incident number that's provided, that will demonstrate that you've made a police report about the claim that your weapons were lost in the process of an eviction in Redford. And then you'll have to submit that to bond compliance. That email address should be on your pretrial release order, but we'll also give you an updated pretrial release order because that condition has been added, as will likely some conditions regarding exchanges for parenting time on there. And then I'm not making any changes to contact between the complaining witness and the defendant at this time. We'll wait to see if the changes that are going to be made today will be sufficient, and I can consider additional requests at a later
I
date.
don't think anyone's requesting any other change.
Okay, that sounds good. Just let us know what's decided here, if you can come up with something, and we'll place it in the order.
Thank you. Good?
I think so.
Okay, I'm check.
Okay.
I love you guys. I love every single one of you. Be safe, be well, sleep sweet, and much love.